In 1794, Eli Whitney received the patent for the cotton gin, a machine so simple that plantation owners across the South had already copied it before the paperwork cleared. What followed was 14 years of litigation that cost Whitney nearly everything he had earned, exposed serious weaknesses in early American patent law, and produced almost no meaningful financial return for the man who built the machine. It is one of the clearest early examples in American history of an inventor being systematically outmaneuvered by the people who stood to profit most from his work. Eli Whitney was born in Massachusetts in 1765 and graduated from Yale in 1792. That same year, he traveled to Georgia to take up a tutoring position and study law. He ended up staying on the plantation of Catherine Greene, the widow of Revolutionary War General Nathanael Greene near Savannah. It was there that he learned about the central bottleneck choking the southern cotton trade. The cotton grown across the inland South was short staple cotton. Unlike the long staple variety grown on the coast, short staple cotton had seeds that clung stubbornly to the fiber and had to be removed by hand. A single worker could clean about 1 pound of cotton per day. The crop was everywhere. The demand for it in British textile mills was strong and growing, but the processing constraint made large-scale production economically marginal. Whitney spent approximately 10 days designing a mechanical solution. His cotton gin worked on a straightforward principle. A wooden drum fitted with wire hooks rotated and pulled cotton fiber through a mesh screen. The gaps in the screen were too small for the seeds to pass through, so they were stripped away. A second rotating brush cleared the hooks after each pass, preventing clogging and keeping the machine running continuously. The result was a device that could process around 50 pounds of clean cotton per day, with some accounts suggesting up to 100 pounds under ideal conditions. Either figure represented roughly a 50-fold increase over hand processing. Whitney filed for a patent in June 1793. It was granted in March 1794. Whitney entered into a partnership with Phineas Miller, the manager of the Greene estate, to commercialize the invention. Their plan was not to sell the machines, but to retain ownership of all the gins and charge plantation owners a toll of 2/5 of all cotton processed through them. Whitney would build the machines in New Haven while Miller managed operations in the South. Together, they aimed to establish a network of gins covering the major cotton-growing states. The plan had a fundamental vulnerability. The cotton gin was mechanically uncomplicated. There was no specialized component, no unusual material, and no technique that required industrial expertise to replicate. A capable blacksmith or carpenter could examine the machine and build a working copy within days. By the time Whitney's patent was officially granted, plantation owners across Georgia and South Carolina had already done exactly that. Unlicensed gins were operating openly and at scale before Whitney and Miller had processed a single commercial bale. The planters' argument for doing this was that the design was too obvious to be a genuine invention, that the patent was therefore invalid, and that Whitney had no legal right to collect fees. This position was put forward by men who were, themselves, major property owners operating under legal systems built around the protection of property rights. They applied those principles selectively. Whitney and Miller began filing patent infringement suits in Georgia in 1795. Over the following 12 years, they pursued cases in multiple southern states. The legal record from this period documents a consistent pattern: hostile juries, uncooperative witnesses, evidence dismissed on technicalities, and verdicts that favored the defendants regardless of the mechanical facts. Georgia's courts were composed of judges and jurors who were plantation owners themselves or were economically dependent on the planter class. In cases where Whitney could demonstrate that an unlicensed gin was operating, defendants denied profits, withheld financial records, or produced testimony that contradicted the physical evidence. Courts accepted their accounts. The statutory problem compounded the practical one. The Patent Act of 1793 required an inventor to prove two things in court: that the defendant had reproduced the protected design, and that the defendant had profited from doing so. The first element was demonstrable. The second required access to plantation financial records, and defendants had every reason to produce figures that showed no profit or to refuse to produce figures at all. Under the law as written, Whitney could be standing in front of an unlicensed gin that was obviously identical to his own design and still lose the case because he could not independently verify what the defendant had earned. Miller and Whitney filed at least 60 lawsuits over the course of the patent period. They lost nearly all of them. The few cases that produced favorable rulings rarely resulted in damages that covered the cost of pursuing them. In one Georgia case, Whitney presented direct evidence that the defendant was operating multiple unlicensed gins and had sold thousands of pounds of processed cotton. The jury returned a verdict for the defendant on the grounds that Whitney had not conclusively proven the machines cost the profit, rather than other factors on the plantation. This kind of reasoning was applied repeatedly across different courts and different defendants. Phineas Miller died in 1803, partway through the litigation campaign, leaving Whitney to manage both the manufacturing operation and the legal battles with reduced resources. Several of their manufacturing facilities in the South were also destroyed. At least one gin house fire is documented, though whether this was arson connected to the patent dispute or an accident has never been definitively established. Whitney and Miller won their first significant court victory in Georgia in 1807. It came 12 years after litigation began. By that point, the legal costs had erased almost everything Whitney and Miller had received in licensing settlements. The damages awarded in the 1807 case were small relative to the scale of the infringement. Several southern states chose to negotiate directly rather than litigate endlessly. South Carolina reached an agreement in 1802 and paid $50,000 for a statewide license. This was driven in part by the political calculation that ongoing litigation was drawing unwanted attention to the scale of infringement within the state. North Carolina paid approximately $30,000. Tennessee negotiated a separate arrangement for around $10,000. These figures sound significant in isolation, but the payments were drawn out over years, were frequently disputed, and were never delivered in full on the agreed terms. The negotiations themselves were not straightforward. South Carolina's legislature debated whether to make any payment at all, with representatives arguing that the patent was invalid and the state had no obligation to recognize it. The $50,000 figure was a compromise reached after extended debate, and portions of it were withheld on various pretexts after the agreement was signed. Georgia, the state where infringement began and where it was most extensive, effectively avoided paying meaningful compensation throughout the active life of the patent. The state's political and legal establishment had the leverage to hold Whitney off indefinitely, and it used that leverage consistently. The total amount Whitney and Miller recovered across all state settlements and court awards, minus legal costs, left them with a fraction of what the invention had actually generated for the Southern cotton trade. Whitney's patent expired in 1807. He petitioned Congress for a 14-year extension, arguing that the entire original term had been consumed by litigation rather than commercial operation. The argument was factually accurate. Whitney had spent the patent period fighting infringers rather than profiting from his invention, and there was clear documentation to support this. Congress declined the extension. Southern representatives, who collectively spoke for the planter class that had been infringing the patent for 12 years, blocked it. The official reasoning was procedural. The functional outcome was that the same political class responsible for the infringement used its congressional power to ensure Whitney could not extend his ability to seek compensation. With the extension denied, the patent lapsed, and the cotton gin entered the public domain. Whitney received no further royalties. The economic impact of the cotton gin extended far beyond Whitney's personal finances. Between 1790 and 1860, American cotton production increased from approximately 1.5 million pounds per year to close to 2 billion pounds per year. The domestic cotton market went from a secondary agricultural sector to the dominant driver of the American economy. By the late 1850s, cotton represented more than half of all American exports by value. This expansion was not possible without a corresponding expansion of enslaved labor. Cotton cultivation was intensely manual at the growing and harvesting stages, even if processing had been mechanized. The enslaved population in the United States grew from around 700,000 in 1790 to approximately 4 million by 1860. Historians have argued that without the cotton gin, the declining profitability of tobacco and the limited expansion of other southern staple crops would have slowed or reversed the growth of slavery as an institution. Whether or not that counterfactual holds, the factual record is that the gin's introduction coincided directly with the most dramatic expansion of American slavery in the nation's history. Whitney's surviving letters from this period deal almost exclusively with his patent battles and cash shortfalls. There is no documented reflection in his correspondence on the relationship between his invention and the growth of slavery. Whitney abandoned the southern market entirely after the patent expired. He shifted his operations to musket manufacturing in Connecticut, working under federal government contracts. His New Haven factory produced muskets for the United States Army during the early 1800s, and his manufacturing methods contributed to the development of production systems using standardized, interchangeable components. The claim that Whitney invented interchangeable parts manufacturing outright is overstated, as similar methods were being developed in Europe and elsewhere at the same time, but he implemented and demonstrated the approach effectively in an American context, and his contracts with the federal government gave him the financial stability the cotton gin never provided. He died in 1825, having spent roughly 3 decades dealing with the fallout from an invention that took him 10 days to design. The Whitney patent dispute left a clear record of how early American intellectual property law operated under political pressure. The Patent Act of 1793 set a standard of proof that was extremely difficult to meet when defendants could conceal financial records. Courts in states with strong planter interests were effectively closed to outside inventors seeking enforcement, and Congress, which contained representatives of those same interests, could be used to block legislative remedies. The dispute produced no significant reform of patent law at the time. The 1793 statute remained in effect until 1836, when a broader revision addressed some of its procedural weaknesses, including changes that made it easier for patent holders to prove infringement without relying entirely on defendants' self-reported financial records. By then, the specific lessons of the cotton gin case were 4 decades old, and the invention itself had long since transformed the American economy in ways that could not be reversed. There is also the matter of scale. Whitney did not lose a minor commercial dispute. The cotton gin generated more economic activity in its first 2 decades than almost any other single mechanical invention in American history up to that point. The men who copied it freely accumulated wealth that funded political dynasties, expanded plantations, and underwrote the further entrenchment of slavery as an institution. Whitney spent those same years in court, largely losing. The disproportion between what the invention produced and what its inventor recovered is not incidental to the story. It is the story. The core facts of the case are straightforward. Whitney built a machine that was genuinely useful and genuinely novel. It was copied immediately and at scale by people who had the political and legal leverage to avoid paying for it. The enforcement mechanisms available to him were structurally inadequate to the task. He recovered a fraction of what the invention was worth, and spent the rest of his working life in a different industry entirely. That is the record. If you enjoyed this video, subscribe so you'll never miss another episode.